Good morning.
We're turning now to live coverage of the Ninth Circuit Court of Appeals in San Francisco and their case on Proposition 8, the ballot measure approving a ban on same-sex marriage. This is live coverage on C-SPAN.
Good morning again, Mr. Cooper.
And good morning again to you as well, Your Honor. The people of California and Americans throughout the country are engaged in an earnest and profound debate about the meaning, purposes, and definition of marriage. The issue is a momentous one, for it goes to the very nature of an ancient and ubiquitous social institution that is, in the words of the United States Supreme Court, fundamental to the very existence and survival of the human race. So this court is presented with, in our submission, this fundamental question. And it is whether the definition of marriage, that momentous issue, is one for the people themselves to resolve through the democratic process, as they did in enacting Proposition 8, or whether our Constitution takes that issue essentially out of their hands and decides it for them, as the plaintiffs argue here.
Could the people of California reinstitute school segregation by a public vote?
No, Your Honor.
Why not?
Well, Your Honor, that would be inconsistent
With what?
with the United States Constitution.
As interpreted by the U.S. Supreme Court.
Yes, yes. Yes, Your Honor. And so the issue,
But they probably
obviously,
could have done that in 1870 or 80 or 90, right?
very possibly, Your Honor. Yes, very possibly.
How's this different?
Your Honor, this is nothing like for example, the racial restrictions at issue in Loving, where there is simply no legitimate, rational basis whatsoever on any purpose of marriage that one could possibly conceive to deny the right of a mixed-race couple to marry on every basis on which one can identify a purpose of marriage. A mixed-race couple satisfy those purposes. So the question is...
Now you suggest that Baker would mandate that the state has an absolute right to prescribe the conditions upon which the marriage relationship between its own citizens should be created, correct?
Not an absolute right, Your Honor. We agree that that right is limited by whatever restrictions the United States Constitution may place on it.
Okay, so then Loving versus Virginia falls right into that restriction.
Directly, Your Honor, in the Supreme Court in Loving said that the racial restriction violated the central meaning of the 14th Amendment, both its due process clause and its equal protection clause.
So if I agree with that, then what do I say is the general notion when confronting Turner v. Safely or Safely?
The case dealing with the right of prison inmates
right.
to marry. Your Honor, the central, I guess, point that we want to advance here is this: what is the distinguishing characteristics of opposite-sex couples that are relevant to interests that the state has authority to implement?
Are you arguing to me that it's enough for a rational basis for the federal court to get involved in that right of marriage?
We are arguing that the test that applies here is a rational basis test, and that if there is any rational basis for the opposite sex traditional definition of marriage, then that traditional definition of marriage must be upheld, and only if this court concludes that there is nothing to say in favor of the definition of marriage that has prevailed in this country and in all places, essentially at all times since time immemorial. There's nothing to say in defense of it. There's no rational basis for it. Then this court would have to strike it down. But that is the test that we submit to you that applies, Your Honor. And we believe that there is clearly a rational basis justifying the traditional definition of marriage. The key reason that marriage has existed at all in any society and at any time is that sexual relationships between men and women naturally produce children. Society has no particular interest in a platonic relationship between a man and a woman, no matter how close, no matter how committed it may be, or emotional relationships between other people as well. But when a relationship between a man and a woman becomes a sexual one, society immediately has a vital interest in that for two reasons. One, society needs the creation of new life for the next generation. But secondly, society its vital interests are actually threatened by the possibility that an unintentional and unwanted pregnancy will mean that the child is born out of wedlock and is raised by, in all likelihood, its mother alone. And that directly implicates society's vital interests, both in terms of its immediate interests, because society will have to step in and assist that single parent, in all likelihood, that is what usually happens, in the raising of that child, but as well in the undeniable fact that children raised in that circumstance have poorer outcomes.
Well, that sounds like a good argument for prohibiting divorce, but but how does it relate to having two males or two females marry each other and raise children as they can in California and form a family unit where children have a happy, healthy home? I don't understand how that argument says we ought to prohibit that.
Your Honor, the point in the question is whether or not the state of California has a rational reason for drawing distinction between same-sex couples who cannot, without the intervention of a third party of the opposite sex, procreate, and opposite-sex couples who not only can procreate, but can do so unintentionally and create unwanted pregnancies. That is not a phenomenon that exists with respect to same-sex couples.
Well,
the overriding.
But what is the rational basis for an initiative that, when California law really says that homosexual couples have all the rights of marriage, all the rights of child rearing, all the rights that others have, what is the rational basis then? If in fact the homosexual couples have all of the rights that the heterosexual couples have, we're left with a word, marriage. What is the rational basis for that?
Your Honor, you are left with a word, but a word that is essentially the institution. And if you redefine the institution, if you redefine the word, you change the institution. So it is you cannot separate the two. The name of marriage is effectively the institution, and the issue here is whether it will be redefined, essentially, to be a genderless institution that bears little or very no relationship to the traditional historic purpose of marriage.
Why aren't the merits of this case controlled by Romer? Because after all, before the proposition was passed in California, same-sex couples had the right to marry. The proposition takes it away. Isn't that exactly what the proposition in Colorado did?
Your Honor, in Romer, the court was dealing with a sweeping law that placed undifferentiated burdens and disqualifications on homosexuals.
So if you take away a bunch of rights, that's bad, but if you just take away one right, it's okay?
Your Honor, it isn't a question of taking them away. The Supreme Court...
Did or did not same-sex couples have the right to marry before the passage of Proposition 8 in California?
Your Honor, the California Supreme Court affirmed that they did, yes. And the people of California disagreed with that, and the people of California reversed it.
How is that different from what happened in Colorado? A few local communities decided that they wanted to extend preferred status to individuals, homosexuals, gays, lesbians, etc. And the voters of Colorado passed a proposition saying you cannot do that. You have no right to do that. Stop doing that.
Your Honor, Amendment 2 rendered homosexuals strangers to the law. It essentially eliminated any and all protections for homosexuals with respect to the ordinary pursuits of civic life, as the court put it. It was a sweeping, undifferentiating, essentially rendered them an isolated class and strangers to the law altogether. The court stressed that it was an unprecedented in our jurisprudence kind of statute. The traditional definition of marriage, Your Honor, is anything but unprecedented in our jurisprudence. It has existed throughout the history of this country. It has been the governing understanding and definition of marriage in this state since its founding, and basically throughout the country and throughout the world for all time. The definition of marriage is not anything like the kind of statute that the court was dealing with in Romer. And in fact, in this case, I would submit to you that the question is, your question, Your Honor, is governed by the Crawford case, where the court said that it would refuse to interpret the 14th Amendment, and these are its words, to require the people of a state to adhere to a judicial construction of their state constitution when that constitution itself vests final authority in the people. And so,
but you've told us that the people of California could not reinstitute racial segregation in public education. So we know there are some things they can't do.
They certainly can't do that.
Without flying in the face of the 14th Amendment. The Romer case opens with a quotation from Justice Harlan's dissent in Plessy. And here's what Justice Kennedy says: "The Constitution neither knows nor tolerates classes among citizens. Those words now are understood to state a commitment to the law's neutrality where the rights of persons are at stake." Aren't you flying right in the face of that?
Your Honor, if there are no reasons, no rational reasons to distinguish between citizens, then the Constitution does not permit the law to distinguish between them and treat them differently.
The proponents of the ballot initiative in Colorado made the perfectly logical argument that all they were doing